So that's 10 o'clock on Saturday, July the 29th. If you'd like to come to that, give my office a call, 931-363-7222, and get on the RSVP list. It's a big venue, so if you can't get registered, we welcome walk-ins. We always do, just like we do here at WLX when we have it at the Country Cafe in the back.
Yes, indeed.
We got plenty of room for people to walk in. So we just like a head count because Miss Tammy likes to make refreshments. And I don't like screwing around at the last minute putting up tables and chairs. So we like to have a good idea what's coming. But we're pretty informal, and I think you'll enjoy it. People do. My record so far is somebody who drove 4.5 hours to be there and then did it twice. Did it at one, and then next time came and brought his mother and his wife. And so that's our record. So it's worth the drive if you're anywhere nearby, a county or two away. If you don't want to wait till the next one, I think we got another one somewhere in August. I'll bring that up as they get closer to it. So
Sure.
But what I want to do is, we do this as a progressive show, and we kind of move through the topics at the beginning, and we talked about last will and testament. We talked about the probate process and how that's affected by that. Then we spent the last week or two discussing putting property in trust, because a lot of people don't understand that trust is an option, and it is. I mean, trust distributes property after death, just like other instruments do, but it does it uniquely. It does it without any probate. You avoid all those hassles I talked about. I won't go through them again, but there's some serious disadvantages to the probate process.
Yes.
And you can avoid all of that with the trust. It is what we call a 100% probate avoidance technique. And you just put your property in the trust, and we talked about that because you're in the real estate business. We used a deed as the example of how we vest property with a trustee to put it into the trust. And once that's done, it's a one and done. You just go about your business, and at death, or if you're a couple at what we call the second death, property transfers to your heirs, completely privately, probate free, rapidly, much less expensively, and it works like a well-oiled machine.
Yes.
And so we covered most everything there was with the trust. And so as we naturally progress through this, the next thing that sort of comes up is this concept of an asset protection trust. And when you say asset protection trust, another way to think of that is a creditor protection trust. And of course, when I'm talking about creditors, I'm not talking about, you got a car loan and you're paying it for the next couple of years. Or I'm talking about future creditors, or a creditor is somebody. Let's take a car loan. If you have a car loan and you're making payments, that's not a creditor because you have an agreement and a contractual obligation to do this and perform. If you default on your note and they sue you and get a judgment, now they're a creditor. So then when we talk about creditors, that's what we're talking about. So people say, I don't have any creditors, I don't have any debt. Well, that's close, but what we're talking about is future creditors. Now, the future creditor most people are worried about is long-term care.
Right.
Okay. And so the nursing home, well, not technically the nursing home, but TennCare. That's a creditor they're worried about. But it really affects all creditors. So that's what a creditor protection trust or an asset protection trust is for. Now, these things have existed for a couple of centuries. Okay, trust law is firmly rooted in our common law jurisprudence. So they're not creatures of statute that the legislature just changed at a whim. And we've been using them for asset protection for all this time. But in the last several decades, we've been using it for protection from nursing home or from long-term care since we developed the Medicaid Act in the early 1960s. Okay. So the concept, what do we mean when we say asset protection? So asset protection is a way to put property in a specific kind of trust, and then your creditors can't get at it. Sounds almost too good to be true. Well, there's more to it. There's more to it than that. Now, we did talk quite a bit about the revocable living trust the last couple of weeks, right?
We did.
And I did say that when you make a revocable living trust, you are the maker of the trust, the trustor. You're also the trustee of the trust, the person that controls the property in the trust, and you're the beneficiary during life.
Yes.
Now, if you're all three parties to a contract like that, you have what we call complete and unfettered access to the property and control of it. So you can do whatever you want with the property, whenever you want. You can spend it, give yourself the money. You can sell it. You can do whatever you want with it. Now, when you have that kind of access and control of property, you don't get creditor protection. Okay, you can't have your cake and eat it too, which means you can't just put everything into a trust, maintain all the control and access to it that you want, and then tell your creditors to go pack sand. They can't get at it. Okay, it violates the fundamental nature of property law. So the revocable living trust, although a wonderful tool, I'm not belittling it in the least. We do a lot of them for people in midlife. people who say, I'm not worried about long-term care just yet. Kind of like I said when I was in my 30s and 40s,
Right.
I'm not worried about that yet.
Right.
But we do a lot of them. It's a grand tool, but it has one limitation. And that limitation is it does not protect you, the maker of the trust, from your creditors during your lifetime, which is the concept of an asset protection trust. I talked at length at how you can protect from your kids' creditors all day long. Any trust would do that.
Right.
But that's protection after you don't have it anymore and it passes after death. So the concept comes up, can we use this asset protection trust concept where you put property in trust and your creditors can't get at it to our benefit? Okay, so to understand how one works, I mentioned the concept of access to the property and control of the property. Okay?
Okay.
Big difference between the two. What we're going to do is we're going to create a protection trust where we don't have any access to the property. We're going to maintain infinite control, but not access. Now, those are legal terms, and I'll explain them here in just a bit. But when you hear that, don't panic, because this is an irrevocable trust. And a lot of folks say, irrevocable trust, oh man, that means the stuff is gone. I'll never see it again. I can't use it. It's just gone. And that's not the case. That is not the case at all. It's available to us. We have tons of control over the property. We're just going to restrict our access. And the reason we do that is this. A fundamental nature of property law is that if you have access to an asset, so do your creditors, which means if you can go to the bank and take $100 out of your bank account and put it in your wallet, you've got access to that. You can directly take the property out of the bank and give it to yourself. Mm-hmm. When you have access, you cannot defeat a creditor. If you have a valid creditor, they're entitled to be satisfied. And
Sure.
if you don't pay them, then they can go involuntarily satisfy themselves. And that's fair. That's only fair.
Sure.
So if the concept is this, I tell people to memorize this, and as we go forward, things are always going to come back to this fundamental concept, and that is, if you have access, they have access. Or I like to say, if you can get at it, they can get at it, meaning your creditors. Okay, or as we're going to focus in on long-term care, which is going to be 10 care. The nursing home never takes anything. You hear those stories, but it's really not like that. It's government through 10 care that takes property.
That's correct.
And so if you can get at it, they can get at it. So we want to create a legal situation where basically we can't get at it. If we do, then they can't get at it. Now, this is what I call the Paul Harvey moment. Because when you hear that, you think, well, I don't think I'm even interested in something where can't get at it and give up control. It's my property. I don't want to do that. This is the Paul Harvey moment. What was Paul Harvey known for?
The rest of the story.
The rest of the story. So stick around for the rest of the story, because when I say you can't have your cake and eat it too, but this asset protection trust can get you about as close to that as possible.
All right.
And I'd really think it's not much you have to give up to live with this. Now, we're on radio, and I wish the heck I had a whiteboard I could do, and I guess maybe we could on Facebook. But when I talk about it, I'll try to explain it as best I can, and you can have to just visualize it.
Well, you've got my attention.
Yeah. But and we may not even. I know we won't get through it all. It's at least a couple of shows long to get through. It's maybe 2. But I want to cover the background as to why we even do something like that. So there's only one thing you can do when you're not in care. Okay, so you and I and your trainee here in the room, none of us are. We're in what we call pre-planning. If you were interested in protecting your assets from long-term care, this is pre-planning, and pre-planning is defined as you're not in the facility. You're not in a nursing home, and you're not really knocking on the door, right? You're not like going there soon. So pre-planning I define as if, you and your wife come to me and say, hey, Stan, my wife and I, we've been working all our lives. We have this lifetime of wealth that we've built up. It is what it is, but it's ours, and we've accumulated it. We've worked hard to get it.
Right.
And if one of us requires long-term care, we really don't want it all to be consumed on our care, long-term care industry. And so that's what we call pre-planning. Now, we're naturally going to progress a couple of weeks from now into what we call crisis planning. That's where you and your wife come to me and say, Stan, my wife got admitted to the nursing home. What can we do about saving what we have worked for all our lives?
Right.
So crisis means you're already there. Somebody, you or a loved one, is already in care, and we're already admitted. So,
right.
So we'll start off with pre-planning, because in pre-planning, the only tool available when you're not in care is this trust. Once you're in care, there's a bunch of tools that open up. They're called crisis tools, and we can use them, but they're not available because the first criteria for them to work is you have to be in a facility. So they're only available once you get there.
Okay.
So we can't use them now. But if we're worried about it, and if we're smart, because this is an extra tool we have, a lot of people say, well, if I can use all those tools when somebody goes into a nursing home, why don't I just wait till then? Well, a big disadvantage of that theory is we can do this one now. Those are available, and they can be limiting sometimes, especially with real estate. And I'm sure as we get into that, you'll appreciate that in your business.
Absolutely.
And a lot of people say, I want my house or my farm to go to my kids and stay in the family.
Sure.
If you come to me in crisis with the order of I want this real estate to stay in the family as the real estate, it's tougher for me. It's a lot of hoops to jump through, a lot of legal. We can do that, but it's a lot more to it. What's a better idea is to protect that asset early, and then we don't ever have to worry about it.
Exactly.
So that leads us into this concept of this asset protection trust. And I mentioned, you have access but not control. Okay, so let me just unpack some of that a little bit. We call this an income-only asset protection trust. And that's a generic term. I mean, you can kind of look it up on Google, and you'll get some hits, and you can read up about it. And here's the way it works. It is an irrevocable trust. So like I said, stay with me for the rest of the story, and it won't sound so bad. So we have this irrevocable trust, and we move into it. So it's just trust like anything else. We thrashed out how trusts work, and this is a trust like any other trust. So you move your property into it. So let's take your house. Remember, we talked about that.
Yes,
I want to open an asset protection trust. I want to move my house into it. So we redeed the property to, the trustee of the trust. Because like I said, when property is in the trust, that's just a street vernacular term. What in the trust really means the property is vested with the trustee. So your deed is not going to say Stan Pierchoski anymore. It's going to say Stan Pierchoski, trustee of his income-only asset protection trust. And so that puts it in the trust. Now we put it in there. Let's say we put some money in there too. I don't know, $50,000 in a bank account.
Okay.
Just to make it simple. So we have real estate and we have some cash that we move in there. Now, the concept we want to do is once we move it in there, it is creditor protected. Okay. And the concept is we can't have access to it. So what cannot happen? What is access? I say access is zero. We have none. And my trusts are over the top. They say you can't have access to it under any circumstances. So what am I talking about when I say access? Let's look at that $50,000 in the bank. It's a little easier to describe access rather than using real property.
Yes.
So you got $50,000 in the bank, and let's say I want to take $20,000 out for something. I need a new wheelchair or whatever, medical expense. That $20,000 cannot come out of that bank account and go directly to me, the maker of the trustor. If it does, that is what we call access. It is direct access. And now we're talking about principal. Okay, let me back up a little bit. We call it an income-only asset protection trust because if anything in the trust generates income, like say maybe my $50,000 is earning a couple of % a year, right?
Yeah.
The income can come to me all day long, and that does not affect our creditor protection.
Oh, okay.
And a good way.
Interesting.
The principle is what I'm talking about when I say access. So
Yes.
the $50,000 is what I can't get at. But if it generates $5,000 a year, that can come to me. And a good way to think about the term income-only trust is income is the only thing that can come out of it that doesn't screw it up.
Okay. All right. I'm with you.
So the income can come to me all day long. No, it does not offend what we're trying to do. But we have to restrict our access to the principal. So if I take $20,000 out of that $50,000 bank account and distribute it to myself, I have offended the creditor protection. That's what we cannot do. Now, and I say my trusts go over the top, and they have language in them that says no access to the trustor, the maker of the trust, at any time, under any circumstances. No way, Jose, not a zip, none. I mean, it's strong, strong language. I even go into in the enabling clauses. I state if there's anywhere in here that it looks like it's access to principal, I'm saying now in the enabling clause that it is not access to principal. I mean, we just go over the top.
Sure.
And we do so because, I review court cases. Like I said, these court cases are decades old when these things were thrashed out. And that's what the courts require, and they'll enforce that. If you say that in the instrument, there's no access.
Okay.
So now I've sort of, let me describe what this would look like on my whiteboard.
Okay.
If you imagine this box, and that's your trust, okay? And it's the income-only trust. And you have you draw your house to the left of the box. Then you draw an arrow into the box, and you draw your house in the box now. So that's the transfer of the house from outside the trust to inside the trust or inside the box.
Okay.
Same thing down below. We got a bag of money, and we move it into the trust. Okay, so we move this property in, and now it's in the box. So if we ever want to get at that property, we can't. So that scares people when they say, I don't want a situation where I can't access it. Well, hang on. I'm going to show you how you
Well,
can.
let's clarify access by
Okay.
what you mean. Because,
access is it coming out of the trust and going directly to you, the maker of the trust.
okay.
That's what we cannot do. And so the other thing is what we talked about, control. Access versus control. Access means we can't take the asset out and give it to ourselves. And one of the reasons we offend at is if we take it out and give it to ourselves, now we can get at it. And if we can get at it, they can get at it. Okay, see, so it starts to make sense, and it will make even more sense as we go on. So we put the property in there now. People say, well, I don't like to give up access. Well, let me tell you, but you have infinite control over this property. Now, what does that mean? We use real estate. Put your house in there.
Okay.
$300,000 house.
Okay.
Which is probably not hard to do these days, but
No.
$300,000 house. And so we have a $300,000 asset in the box, correct? All right. You and the wife say, you know what? It's time to move. I want to move to Florida, or we want to move down the street, but we want to sell this house. Can you sell the house? It's like the thought is, it's in an irrevocable trust. We want to sell it. We can't do that. No, that's not true. Sell it. You can sell the house anytime you want. So the question is, you decide to sell. You get a buyer. What do you get when you sell a $300,000 house?
Well, you should get the cash for that.
It's not a trick question. You get $300,000.
Right.
That's right. Okay, now, the $300,000 has to stay in the trust.
Okay.
Okay, to be creditor protected, right? Because if it comes out of the trust, you have access. Now they have access. So now you want to buy the new house. Go buy it. For simplicity, let's say the new house costs $300,000. You buy the new house. You take title to it, just like the old house was in the trust. Now, when you think about it, you had the house, you sold it for cash, you used the cash to buy another house. Has that $300,000 ever left the box? And the answer is no. Suppose you have this $50,000 in the bank, and you say, you know what, this money's not doing squat. I think cannabis stocks are going to take off, so I'm going to buy cannabis stocks. Do it. The cannabis stocks has to stay titled to the trust. Or Home Depot stocks. Say you want to do an Edward Jones or a Raymond James managed account where you just give them the money and they just do what they do with it, right? The accounts needs to be titled to the trust. And the asset never leaves the trust. It's always there. So if you black box this trust, I said we had a $300,000 house, the principal. We had $50,000 in the bank account. So if you black box this trust, there's $350,000 worth of assets in there, right? Mm-hmm. It does not matter that it changes posture from real estate to cash, back to real estate, to gold bars, to cannabis stocks, back to a house again, and somewhere else in Florida.
As long as the asset remains in the box.
It's always $350,000 in there. Now, your creditors really don't care what the posture is. If they're after you to pay them, they just care that you have the asset. So if the first hoop we got to jump through, and there's two of them, is that once you move property into an asset protection trust, it has to stay there to be creditor protected. If it doesn't stay there, it's not protected, and the whole thing we're trying to do is protect it from our future creditors.
Okay.
And so we move the property into it. It has to stay there. That's the first requirement, I call it the first hoop you have to jump through. Now, I've gone to a lot of trouble and a lot of words to make it clear that you have no access. Correct? Did I not?
You did say that.
And I said my trust, I draft my own trust, and the language is very strong. No access under any circumstance. The trustor cannot, no. I just over the top, right? So now I'm going to talk how you can actually get access to the property. And you might think, well, that sounds like a lawyer double talk, right? Well, it's not really access. It's indirect access, and it's not really that. But I'm going to explain how you can get at this property if you need to. And it doesn't violate our credit protection, which is what we want to do.
Okay.
We don't do anything that's not 100% legal. I'm too proud of my law license. I'm not throwing it away.
There you go. I can't blame you.
Because sometimes I explain these things in my seminars, and somebody always asks the question and say, "Is this legal?" And I always chuckle at that because it's like,
that's the world in which you live.
I don't do anything like that. So if you want to get at it, you have these certain trustor retained rights. Trustor meaning the maker of the trust. And there's several of them, but there's one that's really important. And if you look at this drawing you have in your head, where you got the house and the money going into the box on the left side, or what we can call the front door, we can draw an arrow out the back door, which is the right side of the box, and we're going to label that as the unlimited lifetime distribution of principal to our heirs. Okay, now our heirs is basically a class of people. It's typically what we call descendants, but it can be others, but let's just say descendants. And so we are allowed to distribute property out of this trust to our kids. I got 3 kids, so I can distribute property out of this trust to my kids as often as I want, as much as I want during my lifetime. It's the unlimited lifetime distribution of principal. Now, let's think about this. I'm giving them principal. That's the thing I'm not allowed to have, okay? But I can give it to my kids all day long.
Okay.
Now, imagine this. We have to get the arrow coming out the right side of the box, and it's going to my 3 kids. And I decide to give one of my kids $20,000 out of that bank account, okay? Now, when I give it to him, ownership is complete. I've given it to him. Here's $20,000. I can do that. Doesn't offend creditor protection. And I just give it to him. Now, if ownership is complete, what that means is my son can do whatever he wants with it. He can invest it. He can do something wise. He can do something foolish and go put it on Red 23 over Tunica or something. He can do whatever he wants with it, right? It's his.
Right.
Now, included in whatever he can do with it is he can turn around and spend it on my behalf. So if I need this new wheelchair for $20,000, he can go buy this wheelchair and give it to Dad. And that is appropriate. Now, let's talk about why. It's appropriate because, again, sometimes I'll have court cases that I'll review on these shows about what the courts have said about things. And I do that all the time.
Yes.
All 50 states, or at least all the states that are uniform trust code like we are. And because we can learn from that stuff. And what you learn from it is if you do what the courts say is that we'll enforce, you're in good shape. If you do what they don't enforce, so we do what the winners do, we don't do what the losers do. I've got years and years, decades of this precedent that has come out on using these assets for long-term care protection.
Yeah.
And the courts have said 2 things. They said, if this trust says no access to principal, and I've told you how mine, just to say it in no uncertain terms, and the people you can distribute it to under this lifetime right are not obligated to use it on your behalf, then the courts say we will uphold creditor protection. Now, what do I mean by obligated? Okay, sometimes I have somebody says, okay, I want to put in this trust. Oh, it sounds great, I want to do that. But somewhere in the trust, I want you to put a clause that says, if I distribute this money to my kids, they have to use it on me. And I say, well, that'll be interpreted as access.
Right.
And so they can't be obligated. Or somebody will say, I want to put in there, if my wife and I ever get a catastrophic illness and we just life or death have to get at this property, we can't. Well, that's access. Now,
Yes.
and here's how that works. If you apply for TennCare, so you do this trust, it could be years before you go into long-term care, if you go into long-term care.
Right.
You apply for TennCare, they're going to know you have this trust. Probably they look at your house and they're going to see a title to your trust, right? And they're going to say, may we, during the application process, they'll say, may we please see a copy of the trust? And you have to give it to them, because if you don't, they'll deny you for failure to respond to an informational request. Yeah. So we have to send it to them. And I'm telling you right now, I know exactly what they're looking for. They're looking to see if there's any access. And I know exactly where in the trust they're going to look. They understand how this works. They're not questioning it. They're checking to see if you did it right.
Yes.
Okay? Because, let me go further with this. I know this is heavy, and I just know the way to get it across. And I think it's important that people know. But here's why you can't do that kind of stuff. And here's the consequences of doing so. If this thing has access to it in any way, they call it a peppercorn test. If it's there in any way, we've damaged the trust. Okay, we've violated the terms and conditions of asset protection.
Yeah.
And if we do that, then they consider everything accessible. And now if it's accessible, then they can get at it. So here's an example. And this is not one of mine, but this is an example that I learned from, that I read I think it was out of South Dakota, who surprisingly has similar laws in Tennessee, uniform trust code state, as well as their long-term care system is not too different from ours. Anyway, they had something very similar like that, where somebody said in there that, hey, my wife and I, if we have a catastrophic illness where we have to get at this trust, and it's a life or death situation, we need to be able to get at it right directly from the trust and use it to pay for medical bills. And it seems like a reasonable request, right? Well, that's exactly what I said happened. The 10 care, not 10 care, whatever 10 care is in South Dakota, okay, whatever long-term care is in South Dakota, I forget, asked to see the trust. And they looked at it, and they come back and said, I see you had access to this in the future if you ever needed it. Since you had access to it, now we have access to it. So we consider everything in the trust countable, or what we call available for paying for your care. Mm-hmm. And so now and you're thinking, okay, but the folks that wrote the trust said, well, wait a minute, we never did use it. We never had a catastrophic illness, so we never did access it or take anything out. Herein lies here's the rub. The courts have also said that if you have the availability, if you can access it, the government can assume you've exercised it to the full extent of what you could have done, which means if we need to get at their property for a catastrophic illness, we need to get at all of it to pay our bills. And they said, even if you never did it, this is a peppercorn test, if you have any access at all, even a promised access that you never used, that's still access. And so the consequences are pretty harsh if we don't do it right. And that's what they're looking for, because I've seen some that were poorly drafted. People, some attorneys that I say don't stay in their lane. I think we talked about that one day. And they do these things. They don't understand those things. They don't. And you can set somebody up for failure like that. So it has to be this concept of no access. And so you have to understand that if you want to do this, these two hoops you got to jump through. One, when you put property in it, it has to stay there. And two, if you ever need anything out of it, you have to do it that way. That back door, I call it, that unlimited lifetime distribution of principal. And everything will be okay if we just do that. But if you do something other than that, they will tag it, and they will not enforce creditor protection.
Wow.
So when you think about it, it's really not that hard to have an irrevocable trust and still be able to use the assets. We just have to distribute it to other trusted people that will use it on our behalf. And so there you really have the best of all worlds, in my opinion. So the way I like to set these up, as I advise people, I say, all right, let's put these up. And when we put property into this trust, let's not put anything into it that we contemplate living off of. Let's keep our income out. And the reason I say that is this. We cannot put everything we own into an asset protection trust. When we talked about the revocable living trust, we put everything there, so it all avoids probate. But we can't put everything into an asset protection trust. And let's think about it this way. If you put everything you own into an irrevocable trust with no access to principal, you can make yourself insolvent. And you don't want to use this back door every time you want $100 to go to Walmart to get groceries on Friday night. Okay,
Sure.
So we don't want to do that. And so you put in there what I call your nest egg.
Yes.
All your real estate for sure.
Sure.
Your real estate, your big investment accounts that you're maybe getting some interest off of, but you're not really cashing them out, living off of them.
Right.
Whoever you are, we can talk about the things that are the best things to put in there. And what's very common is just the real estate is the only thing that ever ends up in these things. Because a lot of times that's the lion's share of people's estate.
Sure.
And so we want to put that in there because we want to get it protected. Now, so if we adhere to those principles, it will be protected. But there's one more problem that comes up when we have any situation that we're dealing with 10 care, and that is 10 care is this magic period called a 5-year look-back rule. I know if you've been looking into long-term care, you've come up with that term.
Heard of this before.
In the real estate business, you probably hear it a lot.
Yes.
Okay. Now, I'm probably going to spend a whole show thrashing that out, but we can go over the basics right now, how that works, because there's a lot to that. It's very misunderstood, too. So a lot of people talk about it, but they don't quite get it right, and you need to understand it. Because that also invades everything we do when we're trying to do 10-care planning. It's just 5. Now, 5-year look-back rule has nothing to do with trusts. Okay, it has everything to do with 10-care. That's written into their act. It used to be 3 years. They changed it to 5 in 2006 when we adopted the Deficit Reduction Act.
Really?
And the day is coming, as sure as I'm sitting in this room talking to you on the radio, the day is coming when they're going to change it. And if anybody's going to do it, it's going to be this administration. So, I've been waiting for that shoe to drop for years, and it hasn't, but it will. And when it does, it's going to be something more, okay? Because back in 2006, the deficit reduction, they weren't trying to reduce our deficit. They were trying to reduce theirs with our property.
Exactly.
The deficit reduction, but the 5-year look back is a unique concept. Well, let's look like, I might as well get into it. Let's look at it like this. The 5-year look back is not, it's a specific 5 years. And you're thinking, okay, what 5 years are they talking about? It's called the 5-year look back rule. So based on that, we know it's a rule and we know it has a time period, but that's all we know, right? So surely this 5 years has a beginning and an end somewhere, or you can't call it 5 years, right?
Right.
So how does it work? Well, for everybody in this room and probably most people listening to me, it's a future event. It hasn't happened yet.
Right.
When it happens, let's fast forward. I'll use myself as an example. Let's fast forward, hopefully 20 years or more, and I go into the nursing home. The doctors say, you got to be in care. So I'm there. And my family decides we need to file for TennCare benefits to help pay for this. Because, we're bleeding to death at $9,000 a month, and, we want the government to, pay what I'm entitled to.
Sure.
And I'll talk about that sometime, too. It is an entitlement. Okay, it's
Yes,
not
it
welfare,
is.
it's an entitlement. And so we want to get qualified for benefits. So I fill out the 16-page application for TennCare, and I send it into them. The day they get it, fax it in, they get it that day. That is day one of the 5-year period when they receive a TennCare application for benefits. Now, what you've done when you give them that application is you have given them the right to look into your financial history for 5 years. Now, that is 60 months is what the statute says, and that is a jurisdictional time period, which means it's not 60 months in a day, it is 60 months. So when they look back in your history, so here, that's the name, they're looking backwards now. So if you file it today, they're looking back 5 years from today. What they are looking for is, have you ever given anything away for less than market value? So the only thing that this rule applies to are gifts. I call them gifts. The statute calls them divestments or uncompensated transfers. So, in other words, if you go to your barber or your hairdresser and they say, oh, your wife's headed for long-term care, you need to hurry up and deed your property to your kid now so they can't get it. And people give that advice and people act on it. Just flabbergastes me sometimes. And so they do that. That's what they're looking for. Okay, son, here's my house. For $10 love and affection, I'm deeding it to you.
Yes.
Well, the kid didn't pay you $300,000 for the house, which was fair market value. You just gave it to them. That's what they're looking for. And if they find any of those, they're going to punish you for it. There's a consequence to the 5-year rule. Now, they call it a penalty. I call it punishment. It's a lot harsher. It's my term is more correct. Okay.
Okay.
So what they're going to do when you give something away is they're going to do a little mathematics, and they're going to sum up all these gifts that you've given away. And again, I want to make this clear. It only applies to gifts. I had a call just the other day where somebody said, we need to come talk to you because we're in our early 80s and we both have some health problems and we want to sell our house, but we're afraid if we sell it, we're going to get dinged by that 5-year look back rule. And it's like, whoa, if you sell it, that's a compensated transfer. Again,
Yes.
You have a $300,000 house and you sell it, you got $300,000. TennCare doesn't care about that. They still have an asset to go after.
Right.
They don't care the posture of it. And it's like, no, it doesn't apply to that. It applies to things you give away. And I'll talk about it more in another radio show, but it can also be like underselling or overbuying things. You can have partial giveaways. So suppose you have a $300,000 house, and instead of just giving it to your kids, say, I'm going to give you a deal. I'm going to give it to you for $100,000.
Yeah.
Well, they're going to consider that a $200,000 gift.
Yes.
Because you've been partially compensated for it. All these have been tried before the ink was dry on the Medicaid Act in 1964. So if you think of a way that you think you're going to defeat them, you're not. Okay.
I can imagine.
If you stay within the rules, we can work these things in our favor.
Sure.
But we don't make stuff up and try to hide assets. I had somebody contact me and said they talked to another attorney and they said, hurry up and take all the money out of your mom's account and just keep it somewhere.
Yeah.
And I asked him, I said, did he say why? He said, yeah, so they can't get it. I mean, you can't get away with that stuff because they're going to see the withdrawal from the bank because they're going to ask for 5 years of bank records because they want to see if you've transferred anything away.
Yeah.
Yeah, it's bad advice. And when they find you doing that, now you're getting in the borderline of TennCare fraud, okay, which we don't ever want to get near.
No.
So we got this period. So they're going to add up all these things you've given away in the last 60 months. Now, if you've given it away 60 months and 1 day ago, it's invisible to them. I mean, they'll see it, but they can't do anything about it. And they know that.
Right.
I've had that happen. Have you given anything away for less than fair market value? Yes, $1.5 million. When did you give it away? 5.5 years ago. Oh, okay, so it's outside our jurisdiction to do anything. That's right. Okay. I mean, they get it.
Yeah.
They're looking to see what you've done in the last 5 years because most people do it wrong. They just run out and start giving stuff away because the mindset is, I've worked all my life. I've got a lifetime of wealth. It's all mine. I worked hard for it, a lot of sweat equity, my wife and I. If they're just going to get it all, why can't I just give it away?
Yeah.
That's the mindset. And the answer is you can. But if you do give it away, you need to know the baggage that comes with it.
You need the
concepts.
rules.
Yeah. So you can. You can title it. You can gift it to your kid today if you want. Nothing's stopping you. But they're going to punish you for doing it. Now, one thing a lot of people ask is, what if I did this 3 years ago? My kid already put $200,000 in a house that he built on it and everything. And
Right.
are they going to come and take that away from my son? The answer is no. When you deeded it to your son, ownership was complete. They do not have jurisdiction to take the property from him. What they do is punish you for giving it away. And so what does that punishment look like? They call it a penalty period. It creates a period of ineligibility, even if you are otherwise eligible in all respects. So if you give it all away and then you apply, hey, I'm eligible. I don't have anything. I've made myself broke. I've given it all away. Well, so you're basically eligible, right, on the application. Well, they create a period of ineligibility to account for what you gave away. And it works like this. Let's use an easy number to use in our head, like $210,000. And I use that number for a reason. Let's say that's the only thing you gifted away, and you did it 3 years ago. Or I did it. I'm in the nursing home. I filed my application.
Yeah.
I gave away a $210,000 piece of property to one of my kids for no value. I just gave it. And let's say it's the only one. Like I said, they'll add them all up, but let's say that's the only gift. And so they're going to say, okay, Stan, we got your application. We looked it over. You're eligible. I mean, you meet the requirements. You meet the medical requirement. You meet the income requirement. And you meet the resource requirement. And we're ready to pay. But we're not going to pay right now because we're going to impose a penalty period because you gave away $210,000 worth of assets in the last 60 months. And so it's a penalty period. How long is that going to be? Well, the penalty period is based on the value of what I give away. Okay. A lot of people say, well, if you give something away, you got to wait 5 whole years before you can be eligible. No, that's not true. It's based on the value. It can be more than 5 years. There's no upper limit to this. But here's how it works. They're going to take $210,000 that I gave away. They're going to divide it by a magic number called the Tennessee Divestment Penalty Divisor. It changes every year a little bit. Right now, it's $7,090.20 per month. So you got the numerator, which is in dollars, the denominator, which is in dollars per month, and that number, $7,090, is supposed to be based on the average cost of care. It's a little low, but they did raise it this year. But so when you divide the two out, of course, the engineer in me tells me the answer is in months. The dollars divide out. And so if we round that off to 7,000, we're going to get a number somewhere around 30 months, right?
Right.
So they're going to say, Stan, we got your application. You are eligible. We are ready to pay. But we're going to impose a penalty period of 30 months because you gave away this asset. Now, their logic is if you'd kept the asset, you could have paid us for those 30 months. I mean, it makes sense. I get their concept. I don't like it anymore, but it helps to understand the way they
see
think.
where they're doing it anyway.
And so now let's think about that. I've got this 30-month penalty period where they won't pay. But what they say is as soon as that 30 months expires, the day it expires, we'll start paying. So we create this situation where we have to be otherwise eligible but for this penalty. And so we have. Now,
right. I
got 30 months now. What are my choices? Well, I can private pay, right? $9,000 a month. But wait a minute. How am I going to private pay? I've kind of given all my stuff away, right? So that might be tough. The only other choice I can think of is I just don't get the care. Now, those are harsh consequences.
Tough
somebody might say, well, your kids can pay. Well, that's not a choice. And I don't know anybody who wants to obligate their kids to do that. Right now, the average cost of care in a full-skilled nursing facility, average, is $8,500 a month.
Wow.
You can bleed to death financially rapidly.
Yes,
there's an end in sight when you're talking about that kind of money. If there's not, then you don't need to be applying for benefits anyway.
Yeah.
I mean, you can be getting the high-quality level of care and just paying for it.
Yeah.
In somewhere else. But, I mean, so those are a harsh place to be. So we want to avoid this penalty period at all costs. And that's what we work us in. So now, all this is about, and I'll thrash the penalty period out, or the 5-year look back more in a future show, but when we transfer that house and that $50,000 to this trust, The trust does not pay us for it. If it did, we wouldn't have accomplished anything, right?
Right.
So it is an uncompensated transfer. It is a divestment of the property when it goes into the trust. So that will trigger this whole concept of 5 years. Now, it's not the 5-year period I just explained because that's a future event.
Okay.
So I call this a 5-year look forward period because it has the same kind of effect. So we know as we move forward, we kind of keep in mind, well, where are we if we applied today? So we put property in trust. A year later, we think, okay, where are we eligibility-wise? Well, we're only 1 year past a transfer. And so, we want to keep that in mind. Now, people will say to me many times, they'll say, well, you're triggering the 5-year penalty period, right? I said, yeah, that's exactly what I'm doing. And you're doing it intentionally. That's right, I'm doing it intentionally. Why would anybody want to trigger a penalty period intentionally? Which is exactly what we're doing. And the answer is we want to get this 5-year period started now while you're healthy and get it behind us and not wait until you're 85, you got issues, and you come to me. I don't know if you can stay out for 5 years, but if you do it pre-planning wise, and I like to say if you do it between 50 and 65, and I'm just picking those ages
Sure.
as a time, I pick that age because now those are a time when we say, all right, I'm kind of at the end of my working life. We're getting close to retirement.
Right.
I'm thinking
Right.
about my wealth, and I'm kind of concerned about what might happen to it if one of my spouse or I gets sick and we have to go into a home. And so I'm
Right.
a little concerned about it. But we're still basically healthy. So if you do this pre-planning and put it in trust now, that 5 years is statistically in the bag. I mean, anything can happen. You can get hit by a bus or stroke out. I mean, of course, that's always there. But statistically, we got about a 95% chance of clearing this 5-year period.
Yes.
And once we clear that 5-year period, this stuff is never in jeopardy ever again. We never have to look at it again. The only thing we really have to look at now is if you go in the nursing home. Dying's a when, nursing home is an if. We don't know if we're going there.
Right.
So if you go in the nursing home, the only thing we have to worry about protecting now is what we didn't put into this trust, which is usually just some money in the bank.
Yeah.
And we can protect that with a stroke of a pen overnight. That's easy to protect. What's difficult to protect at the 11th hour is real estate.
Yes.
Now we can do it, but we can do it easy if we can sell it. But not everybody wants to sell their property in this
Sure.
situation.
Sure.
So if you don't want to sell it now, we got to get creative. And there's some real legalese. We tie up ownership, try to create an inaccessible asset. I'll get to that in a future thing. But we're actually trying to tie up in some sort of joint ownership thing. And there's a lot of rules that affect that. So we got to, that's hard to do. So it's a tougher order for me to protect property and leave it as the property at the 11th hour. The better thing to do is move these big ticket items in, our nest egg, the stuff we're saving for a rainy day, right?
Yes.
And the rainiest day you're ever going to run into is when you run into TennCare and long-term care. So we put that stuff in now and get it the heck out of the way. We never have to worry about it again. That's the advantage of using this tool and not waiting till the crisis tools. Because people say, well, if I can use all those crisis tools, I'll just wait till somebody goes in. Well, you can do that. But this one's not available anymore because this one takes 5 years. And if you wait till you're in, we don't have 5 years. And I can't control that 5 years. That's government imposed. If I could, I'd be retired by now. Or they'd be lined up from here to Columbia
Yes.
wanting to do it. So
Yes.
so it's a very powerful tool if we use it in advance, like we're doing, like I'm talking about, as a pre-planning tool. We can protect all these assets. So what are we doing? I talked before, or I don't think I talked about this yet, but when we talk about going into long-term care, a lot of people hear this concept that you have to have below $2,000, countable assets less than $2,000. I mean, have you heard that?
I have
before?
heard that.
Yeah, people say it all the time. They say, yeah.
Yes, I have.
And the operable word there is the word countable. Not to everybody hones in on the word $2,000. They say you got to have $2,000 to your name. It doesn't mean that. It means $2,000 of countable assets.
Right.
And countable assets is a category. So the legal question that comes to my mind is, well, if countable is a category, could there be other categories? And the answer is yes, there are.
Yeah.
The only category we have to get down below $2,000 to qualify is countable. So can we make countable assets non-countable? Sure. Putting them in this trust is exactly that. That's one. There's many of them. We'll talk a lot about the other ways when we get to the crisis planning tools. But there's other categories. There's exempt, there's excluded, there's inaccessible, there's non-countable streams of income. There are all kinds of categories we can take property and move it. So you can qualify for TennCare and keep all your property, especially as a married couple. When you're single, the rules are a little different, which we'll get into, but they're a little different. There may be some loss when you're single because we don't have what we call the spousal impoverishment rules that we can use to help keep the healthy spouse at home from going broke because, I'm this black hole of $9,000 a month cost. My wife is concerned what's she going to live off of. So we have these rules where we can transfer some property to her. So when we transfer it in this trust, we have to clear this 5 years because that's government imposed. And so we're stuck with that. Like I said, it used to be 3. Now it's 5. The sooner the better is the only thing I can advise because it's going to change. Now,
Wow.
So when we move into this trust, it is now an non-countable asset. It is unavailable to them, especially after we clear the 5 years.
So there's a difference between just what's called an or revocable trust, and then what you're calling an asset protection trust. There's a pretty good difference here.
Well, they're both trusts.
Yes, they're trusts.
They both avoid probate and all that stuff I talked about because
Right.
trust is a trust.
Right.
They're different in what they do during the maker of the trust's lifetime.
Correct.
One protects assets during your lifetime, the other doesn't. And it doesn't because of this giving up access to the property.
Right.
A lot of times I do it. If you can imagine this, I take my left hand and I hold it up and I say, if you have complete access and control over property, then I hold my right hand down low and say, you have no creditor protection. If you want creditor protection, I raise my right hand and lower my left hand and say, you have to give up access to the property. It's the fundamental nature of property law. That's the difference between the two. And it's a super powerful tool.
But now access to the property doesn't mean you can't still live in your home.
Oh no, you can. It's seamless to you.
Yes.
It is seamless to you, and
Yes.
it's so seamless that you can live there.
Yes.
You don't have to move out. That's a good point. You can
Yes.
live there. You don't have to move out.
Right.
You still pay a mortgage if you have one. The
Yeah.
bank still maintains its remedy of foreclosure if you don't pay it.
Right.
So you can't put it in trust and say, bank, go pack sand. I don't
Yes.
have to pay your mortgage. No, you have to pay the indebtedness because that's not a free future creditor. You can't defeat existing creditors. Otherwise, you go buy a bunch of stuff, and when they want paid, you hurry up and put it property in a trust and say, okay, sorry, I don't have to pay.
So that brings up another thought and a question for me. May not have time for this at this moment, but
I noticed you waited till the last 5 minutes.
I
to
did
ask the
wait for the
question.
last second here, didn't I? But if you do have a mortgage, is there anything in the mortgage language or deed of trust language that would prevent you from putting that asset in the trust?
Good question. And a lot of people think if they have a mortgage, they get a creditor. And like I said earlier, that's not. As long as you have a contractual obligation. You're not a creditor until you go to court and get a judgment. Now, but good point, because if you put property that has a mortgage on it into either the revocable trust or the irrevocable trust,
Yeah.
you can do that because there's a federal law called the Garn-St. Germain Act that allows you to do that. Because years ago,
Right.
banks tried to pull that, and they said, well, wait a minute, if you put it in a trust, you change the owner from you to the trustee of the trust, which is exactly what we did.
Right.
We're going to call that the due on sale clause. And we're going to say, okay, you owe us the note because it's been sold. Well, the feds jumped in and said, we're not going to let you do that to people. That's kind of low down.
Yeah. Yeah.
No other way to say that. And so the Garden-St. Germain Act says just because you have an encumbrance on the property, you cannot exercise the due on sale clause in a note. It doesn't give them any. It doesn't give you any relief. You're not giving up any rights. You still owe the mortgage.
Yes.
So the bank is in the exact same position after you put it in the trust as it was before.
Okay.
And so it's been that way for decades. That came out in the late '60s, and so it's been around. The only thing I've ever seen is if you put property into an asset protection trust, and then you want to borrow on it. Now it's up to the lender. A little bit different.
Yes.
Okay? And banks will. Some banks won't, but there are a lot of banks out there because they understand how this works. I mean, if you borrow money on it in this asset protection trust, you have to agree to not make them one of these creditors you're trying to avoid.
Right.
Because they're not going to take a risk. I mean,
Right.
they won't lend it to you if you do that. And that makes sense to me. So, sometimes people take a mortgage on a thing before they put it in.
Yeah. This has been incredibly interesting.
Hopefully now there's more to it. There's more to it.
Sure.
Here's what comes up next week. So stay tuned for a pretty cool example to see how powerful this tool really is.
Right.
And that is, I know people are thinking to themselves, and you might even, when I do my presentation, this question gets asked so often, I made a slide in my PowerPoint about it. And the slide comes up and it says what if I put property in this trust and I don't make the 5 years. Okay. So let's say you put this property in trust, you got a stroke at 3 years.
Right.
Now what? Are we just SOL? I mean, is it just, is it all for naught?
Yeah.
The answer is no. And I have a real live case of mine and real numbers that I use for an example to show just how powerful this thing can be. Now, we didn't even make the 5 years, and we still are going to come out smelling like a rose. So I'll start with that next Friday because I want to go through it so you can get the full effect of
Sure.
it. So.
Before you go, let's talk about how we can contact you and your office and people that want to know that.
Sure. Of course, we're Pierchoski Estate Law, Pierchoski Elder Law, and we're located on the square in Pulaski. And my number is 931-363-7222. Or you can go to my website, which we made real easy for you, estateplanstan.com. You don't have to spell my last name. Estateplanstan.com. There you can see my calendar, and you can see when the next seminar is. The next one's July 29th, which is a Saturday at 10 o'clock at the Star Theater, which is right beside my office on the square in Pulaski. Or you can get my phone number and my email and ask a question that way if you want, or call and set up what we call a 15-minute call.
Very good.
I always refer to those as 15 lawyer minutes because they.
A lawyer minute's different, isn't it?
Yeah, that's right. I always deal at court and say, this hearing's only going to take 30 minutes, Judge. And one judge once said, is that 30 real minutes or 30 lawyer minutes?
I've sat in a couple of those.
Yeah.
I know what you mean. That's pretty interesting.
But it's something I do so you can, if you want to make that call, we schedule it and I will call you, and then my time and attention is dedicated to your question. If you call me in the middle of the day, the girls are not going to let you through. I'm working on something. They won't.
Yeah.
But you can set this up.
Set the time up.
It's the best way to do it. And we do it pretty quickly too. So
EstatePlanStan.com.
Yep. And we're here every Friday from 8 to 9 on the talk radio here at WDXE.
That's right.
So tune in and get your questions and call in and ask them.
All right. Well, stay with me for a moment after we leave. I got a quick question for you myself.
Okay.
And I'll let you go. I promise. Estate Plan Stan, everybody, every Friday here from 8 to 9. And always informative, always brings more questions to me. Again, his phone number in Pulaski, 931-363-7222. Go by and see him today. Thanks, Stan, for being in this morning.
Always a pleasure, Jeff.
This is WDXE, W287AA, and W237FD Lawrenceburg. Broadcast services